of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about waivers in this set of videos, and what's the procedure generally for a waiver? Well, first you of course prepare the waiver, and then it's submitted to the proper government official. Now they've got three options really. They can flat out deny the waiver, and if they deny it flat out, then it's because there was insufficient evidence. It blatantly would never be approved, meaning that you didn't have really what was needed in any respect at all to get it approved, and they deny it flat outright. Second option is they approve it, okay, and if they approve it, you're home free, assuming you're not inadmissible on other grounds. And then the third one, which is actually one of the more popular ones, is they don't deny it, they don't approve it, but they issue what's called a request for evidence, or a notice of intent to deny, and they give you an opportunity to file essentially a rebuttal, or more documents, more argument as to why you should qualify, and then once you get that in, then they would make the final decision. Now, if they find out that you've submitted a waiver and they do your background check, which they will, and they find out that you're inadmissible on a ground, that another ground that has no waivers, they'll deny the waiver. So for example, let's say you committed some crime, assault and battery, and that's a waivable crime, and everything looks good, perfect waiver, but then they find out you also have a conviction for possession of methamphetamines. Well, there is no waiver for that in regards to admissibility. So they would deny the whole waiver based upon the fact that even if they were to approve it, you're still inadmissible to the U.S. based upon the other crime. So just as a side note on that other crime, you need to get criminal relief to get that vacated, so that you can then apply for the waiver on the crime of which there is a waiver. Okay, more on the coming videos.